here in Europe, and all kind of different times around the world. Thank you so much for those of you who are still hanging in there after 2 full days, very full days of incredibly interesting content from a huge variety of speakers. We've been very lucky to have such a great variety of speakers sharing their knowledge and extensive research as well in many cases. So we are just sort of wanting to make sure that we're all on the same line. So when we start a session, we're just reading out a sort of disclaimer, whatever you want to do, that this conference aims to start a strengths-based conversation about neurodiversity in the criminal justice system. The core objectives are to bring interested people together to share knowledge and exchange ideas, provide a platform for interested people to listen to and learn from each other, provide a safe and inclusive space for people to explore the area of neurodiversity from a strengths-based perspective. Conference organizers operated an inclusive approach to speaker inclusion, and we sought to involve all persons interested in presenting. So just so that everybody is clear on what the basis we're working for. I'm Charlotte Rollin. Some of you would have met me before. I'm chair of the Institute of Neurodiversity. I'm autistic myself, in the process of finding out whether I'm also ADHD, late diagnosed, and obviously finding all this hugely interesting. We have large amount of neurodivergence in my family and in the wider family, so these subjects are very close to my heart. I want to now introduce Professor. See, now I've lost a piece of paper. I'm so sorry, Nathan. This is bad. So,
you're okay.
Professor Nathan Hughes of University of Sheffield. His presentation is called Ensuring Rights to Justice for Children Affected by Neurodisability, Implementing the Requirements of the UNCRC General Comment 24. Nathan Hughes is Professor of Adolescent Health and Justice and head of the Department of Sociological Studies at the University of Sheffield. His research is at the interface between social policy, criminology, and developmental sciences, highlighting the disproportionate prevalence of various childhood health and developmental difficulties among young people in our criminal justice system. In particular, his work focuses on the criminal justice practices and interventions that discriminate against, disable, and criminalize young people as a result of neurodevelopmental impairments, including learning disability, communication difficulties, and traumatic brain injury. Welcome. We are delighted to have you here, Nathan. Over to you.
Thank you. This is where I get the technology wrong, but I shall give it a go.
Oh, well, better you than me, but I've been there as well.
There we go. Sorry, everyone. Does that look okay?
That looks good. That looks good.
Brilliant.
Well done.
Thank you. So yeah, just to start to say thanks for the invite to speak to this conference, and thanks to everyone who is hanging in there and still attending and given so much time to this kind of really important area of practice. I'd really hoped to come along to far more of the conference, but we've got some horrible industrial action pending in the UK, and I've been completely sidetracked by that over the last couple of days. So apologies if some of the stuff that I say kind of has been said already, or kind of revisits in far briefer term stuff that you've unpacked quite significantly over the last couple of days. But hopefully by introducing the framework around the UNCRC General Comment, we can perhaps locate some of those more nuanced discussions that you've had so far within this framework, and think about what that allows us to do in terms of ways forward. Before I start to do that, though, I did just want to say, to touch a bit on terminology and on conflicting terminology. I've got a bit of a tendency to unhelpfully kind of vary my technology when I talk, depending on who I'm talking to in the kind of case that I'm trying to make, and I'll probably not be internally consistent with the language I use. But today I'm using the term neurodisability or neurodevelopmental disability, and there are a couple of reasons why we do that. Firstly, trying to use the term in opposition to a narrower focus on kind of clinical diagnoses of specific neurodevelopmental disorders. So rather than to talk too much about specific diagnoses of ADHD or acquired brain injury or fetal alcohol syndrome, or whatever it might be, but instead employing that broader term of neurodisability to include people who are experiencing difficulties but don't have a diagnosis. So they've not assessed, they've not had access to an assessment, or they haven't met the kind of clinical thresholds for a diagnosis, but yet still have very particular needs that we need to respond to. And then secondly, using the term disability to locate it within the social model of disability. So, you know, a recognition of societal norms and practices and the discrimination that's at the root cause of the negative experiences of those who are neurodiverse, including here that kind of risk of criminalization. And so for the subject that I'm going to try and cover today, that's really important, because I'm trying to locate it in that far more established kind of disability rights agenda, kind of evoking the legislation to counter discrimination and the requirement of our public services to do that. So recognizing that the conference is about neurodiversity, and recognizing that that's increasingly the term that those with lived experience would want us to be using, and apologetic for not doing so, but connecting that term to that kind of broader understanding of disability and discrimination and legal frameworks. So we're going to start with a kind of broader piece of work that we've been involved in, I guess, in an advert for that work, and an acknowledgement for the collaborators in that work. So this is a review that was published in the LANCET, and it's free to access if you're willing to kind of register on their webpage. And it examines what we call the kind of health determinants of adolescent criminalisation. So the difficulties prior to involvement in the criminal justice system that seem to be particularly common among children and young people in those systems. So it tries to emulate and play on that kind of well-established social determinants of health kind of model, where we're trying to look at the kind of conditions in which people live, that the systems and the policies that shape those experiences that seem to make people at greater risk of poor health outcomes, or to frame kind of health inequalities. And so trying to use that to say, well, you know, what are the kind of health and developmental experiences that seem to make people at greater risk of being in our youth justice systems. So it's not about saying what's the direct cause, that although some of them may be direct causes, and I'll unpack that a bit here, but what are the kind of health factors that seem to fuel these inequalities. And of course, you know, nothing on this list is going to surprise you. It includes the neurodisability that I'll come on to, but equally the kind of challenges with mental health, with experiences of trauma, with various forms of adversity, from abuse and neglect to things like parental incarceration. And really just, you know, framing this whole kind of presentation, and no doubt presentations you've had already, what we really see here again is that it's our most disadvantaged and our most unwell young people who we as a society are placing within our youth justice systems, and in particular in our prisons. So I wanted to frame our concerns with neurodisability and neurodiversity in this broader context, and recognizing that these things are interrelated and not straightforward. And I won't labour this because I'm sure you've seen plenty of prevalent stats over the last couple of days, but you know, in particular around particular types of neurodevelopmental disorders, you can see a real kind of stark and consistent and bleak over representation of young people with these particular diagnoses in our systems. And here they do tend to be diagnoses of disorders, because that's the way in which the literature is set up, and that's the way in which this work has been done. So a very real and stark situation, but as I say, all of this resembling various other health and developmental difficulties that we should be concerned with. And that evidence is starting to be recognised, at least in international law, and it's that I want to focus on today. And it's this second paper in that series. It's, again, you know, free to access if you want to do so, that I'm going to use today to show how, with reference to the General Comment and the UNCRC, what legal frameworks we can now be operating within to try and make sense of the issues I've just described. We note, though, that I'm not the lawyer in this group. You'll see Frances Sheehan's name on the slide there. She is the lawyer. She did all the careful thinking and interpretation for us, and I always put the disclaimer that I'm not going to be able to answer any complex legal questions, but I can defer them to her if people have any that they want me to ask. Just a little on the broader context of this general comment fits within. Clearly, the main kind of framework, legal framework that we would want to be thinking about here is the UN Convention on the Rights of Persons with Disabilities. So this is the best established framework for understanding rights regarding criminal justice, whether adult or child. And it clearly defines disability in terms of how the society responds to and interacts with a person's specific impairments, including the kind of the more apparent, perhaps, barriers around physical access to buildings and transport and so on, but also attitudes and prejudices and exclusionary structures in our public health systems, our health and protection and education and justice systems. And in particular, it offers us the first kind of real framing of an explicit kind of right to access to justice in terms of our legal frameworks. In particular, this Article 13 that's there, that states are obliged to ensure effective access to justice for persons with disabilities on an equal basis with others. And it says a little bit about what that means, how we should interpret that. So it's about the provision of procedural and age-appropriate accommodations that facilitates effective roles as direct and indirect participants. So it covers witnesses, it covers defendants, it covers victims and everything that goes with it. Importantly, the notion of kind of fair access is based on the idea not that everything is done equally, but that we put in the measures that are needed to ensure this access, and that's kind of key to what comes later, I guess, in how we understand and respond to this. The other important framework then is the UNCRC, and you'll likely be very familiar with this. It's the International Human Rights Treaty that sets out all of the civil, political, economic, social, cultural rights for children. It recently celebrated its 30th anniversary, and it's the most kind of ratified treaty in the world. I think 196 states are party to it, everyone except the USA, pretty much. And this brings then the whole set of legal obligations for us to implement in terms of all aspects of society, but in particular conflicts, children that are in conflict with the law. And again, it's this notion about implementing these rights without discrimination, and that kind of non-discrimination doesn't mean necessarily equal treatment for everyone, but the special measures and adaptations that are needed to ensure that rights can be realised. And it's in the context of this framework, and again taking lead from the UNCRPD, that the recent general comment on the rights of children in the child justice system was released. So to explain very briefly what a general comment is, these are really intended to provide guidance for states parties on the interpretation of specific aspects of human rights treaties. So they try and sort of clarify how particular rights might be understood and interpreted. And this is the first one since 2007 to talk about the rights of children in the child justice system. So it's kind of an update on a 2007 note, and tries to incorporate all of the developments that have occurred since 2007. And as you can see in the top right of that, oh sorry, I've not moved the slide. I'm sorry. So you can see in the top right of the slide there, one of the things that it sought to reflect was new knowledge about child and adolescent development and evidence of effective practices. So they put out a consultation prior to the general comment, and many of us replied, and we replied very heavily with a lot of information around both general child and adolescent development and how we now understand maturation of the brain, but in particular the point they then pick up on about where people may have developmental difficulties and what that might mean for their engagement in the system. So firstly, a thank you to everyone who's been involved in this work that we were able to kind of draw together and sell to the committee. Any credit for them recognising this is very much shared between you all. And there are two key paragraphs then of the general comment, which covers a lot more than just the changes around developmental disabilities, but that we can locate this within. The first is this paragraph 28, which boldly states that children with developmental delays or neurodevelopmental disorders or disabilities should not be in the child justice system at all, even if they have reached the minimum age of criminal responsibility. So a very bold statement, and one that I don't even think we wrote into our submission to them. We're usually not bold enough to tell national governments that they shouldn't criminalise young people with disability, given it doesn't usually give you such a good hearing among our kind of political classes. But the idea being that we really should not be seeing people with certainly with diagnosable disorders within our systems at all, and we'd be keen to hear from you whether that's an argument that you think we can be pursuing in our various places. But I want to focus more on the final point of that paragraph, which concludes that if not automatically excluded, such children should be individually assessed. So that the idea that you need to understand an individual child's disability in order to then protect them. And this links to then the later paragraph 40, which talks about kind of safeguards against discrimination at the earliest point of contact and throughout the trial, and arguably after a trial, against this kind of discrimination. So a really bold, I think, kind of set of statements that we can work from in trying to pursue the agendas that you've been debating over the last couple of days in the context of children, at least. Still, though, I think a massive challenge in front of us, and it's that challenge that I want to kind of think about today. That it's one thing to have this document that we can be selling. It's one thing to have the United Nations then pushing individual state parties to tell them how they're responding to their guidance. It's another thing to develop the sort of practices that would enable us to do that. And I got offered some examples of where this might be done, particularly in our work in New Zealand. But again, in terms of any discussion time that we've got, if we're able to hear from anyone about examples of where they think there's good practice that we can learn, that would be fantastic. But the starting point for all of this, clearly, if we're thinking about how do we identify young people to exclude them from our child justice systems, or to put into place the kind of safeguards that we might be thinking about, is obviously assessment and awareness, and consideration to how and when we identify children, and what are the appropriate means to identify them, and what are we actually seeking to identify indeed. And our research, it's a negative picture really. Our research would suggest that screening or assessment to identify forms of impairment, let alone kind of disorders of the type that the guidance refers to, are still very rare within criminal justice agencies, particularly at the early stages of those processes. So if we're really looking to exclude them, we'd be looking to exclude based on the basis of an assessment at arrest or prior to court appearance, not really at sentencing or at custody, where perhaps the most ready assessments of these sorts of disabilities are being carried out. That's a gross generalization. There are, of course, pockets of good practice and good assessments, and in England and Wales we see our diversion and liaison services trying to fill this gap, but the evidence suggests it's far from universal, and the assessments are far from broad enough to capture all the things that we might want them to capture. We've also started to play around with how we can use data linkage to inform these sorts of discussions. So again, work in New Zealand, where they have a very well articulated data linkage system, would seem to allow us to use assessments in health and school settings alongside, to bring those into our criminal justice settings to identify where there might be particular needs. And a good paper by Nick Bowden around autism demonstrates the way that we can see this data flow, but they rarely seem to be informing practice. Even where there are good integrated data sets, it's not clear that they're being operationalized in a way that actually helps the young people that have been assessed in other settings. So we've equally been trying to think about, if it's not about assessment, how else might we be identifying young people? Are there ways in which we can think about allowing our frontline practitioners to more routinely identify and respond to needs that they perceive within young people? So even when formal assessments and diagnoses haven't been undertaken, can our criminal justice professionals operate in a space where they're able to make appropriate decisions? For example, police officers in custody suite in particular can often play a key kind of gatekeeper role in deciding whether someone goes into formal procedures or not. How do we ensure that they're able to make appropriate decisions? And again, I'm going to keep talking about New Zealand, but there we were asked by the New Zealand Law Society to develop guidance that we could use, we could share with advocates within the youth justice system, so that they might be able to recognise the signs of possible disability that they could then use to either change their practice in the way that the General Comment might have us do, or refer people on for assessments. And so we help them to think about a set of signs that they might identify. And of course, if we don't do that, then there's a whole kind of knock-on for ways in which the barriers to access to justice are apparent, and without that kind of assessment early in the process, then there's we're putting into place a whole series of barriers that actually don't play out well for young people with particular difficulties in terms of their experiences in the justice system. And I won't labour on all of these because again they're likely things that you've talked about so far in the conference, but people need to be alert to the barriers that people are facing, either in being able to engage in the system appropriately, being able to understand the language that's being presented to them. Crucially, in terms of the forensic interviewing techniques, and being able to really engage in questioning in a way that allows them to tell their story in an appropriate way, rather than to be tied up in the kind of knots that can suggest to the uninitiated lawyer that these are that this is a story with inconsistencies and lies inherent in it, rather than just someone struggling to break that story up and tell it in the way that they're being asked to do so. So a kind of a recognition, I guess, calling for a recognition of the signs of disability and the steps at which those signs might be kind of realised and understood. But equally, in a paper that's actually just come out today, it's been published as part of a special issue of criminal behaviour and mental health. We've tried to look to the literature to find some answers here. So what are the practices that are out there that people might be able to draw on? We've undertaken a scoping review that provides us with some tentative evidence of the sorts of supports that we might draw on, pre-court supports as well as in-court supports. But there's even this review, without wanting to put you off from reading it, even with this review, we really lack any kind of firm evidence base for effective practices, the sort of evidence base that we can go to convince policymakers or governments or our institutions to put things into place. There's evidence of good practice or qualitative accounts of effective practice, but nothing that really kind of underpins an evidence base that we might kind of generalize from. So really, if anything, within that literature, an argument for generic reforms of court practices, an argument that we should be changing our practices for every young person, or assuming that most of the young people that come into contact with our systems do have forms of impairment, rather than trying to find some off-the-shelf kind of interventions that can do the job for us. And so again, we've tried to provide some of that kind of guidance in the New Zealand system, trying to provide some pointers for generic policing and youth justice practices, so that folk, even without those assessments, can try and make sense of how their practice might assume cognitive and communicative competences and understandings that might not be there. And again, just around why this is important. Without that, everything else starts to unravel as well. So unless you've really got that kind of firm understanding of how someone's able to access the justice system and tell their story and get a decent hearing, then the inappropriate interventions will flow. And there's a paper again there that unpacks it all. But unless we've identified these needs, then we're going to put in place the sorts of interventions that you're not going to serve people well with these forms of difficulty. We're going to use the generic interventions, those that kind of assume metacognitive skills, the ability to kind of think about your own thinking and therefore change your actions. Interventions that we know to be a struggle for the sort of young people that we're talking about today, which for us raises these real fundamental questions about actually whether the principles that we think are underpinning our youth justice systems really are underpinning how we're interacting with these young people. So I'm conscious of time, so I just wanted to kind of say a couple of things about work in progress. The first is that we think a sensible way forward is to try and map out what we call a sequential intercept model. It's not our language, you borrowed it from elsewhere, but to think through the various steps that a young person takes through our systems, including pre-criminal justice, but equally within the justice system too, and to really think about which of those points of intervention should we be assessing, should we be intervening, should we be diverting, etc. So we've done that in relation to brain injury in the UK, and this reflects the parliamentary work that's going on there. But then lastly, trying to do this through a new group, a new global network of academics and practitioners that we'd welcome any of you to join, run through the Global Law Enforcement and Public Health Association, a special interest group that's trying to share these ideas of good practice, trying to push for policy reform and trying to develop and fill kind of evidence gaps that we might be seeing. Stop there. Thank you.
Thank you so much, Nathan. Thank you. The last piece was very good. Anyone can join that, you say?
Yeah. Just drop us an email.
Well, that's great. I mean, what we are trying to do at the Institute is to get our voice more and more as part of everything that's being discussed around us, because it is a bit easier to know what's going on our side of the fence, being neurodivergent, than maybe from people looking at us from the outside. So we really want to encourage much more integrated ways of looking at these things, in terms of not just us being the subject people are observing, but we're actually part of the discussion. So we have one question for you right now, which is, how valuable do you consider the Manitoba Special Courts for FASD as way forward to begin to improve the situation for vulnerable youngsters, and could it be broadened out for other neurodivergent conditions?
Well, I suspect Jeff's got a far better answer to that question than me. I don't know if we're able to invite Jeff to say anything. I'm kind of loosely aware of those courts, but others here probably won't be. Is that okay, or is that just
Yes, that's okay. That's okay.
Sorry to put you on the spot, Jeff.
Is he able to?
Is that me?
Yes.
Okay. I'm not very good with these things either. All I can say is I don't know a great deal. I've been learning from the point of view of being a carer with lived experience, that kind of side. And I've been learning for about 12 years now. And I've been so impressed with a lot of the stuff that's going on in Canada, CanFASD particularly, and also in New Zealand as well. And the Manitoba courts seem to be following the line of what's happening in the US, where you get more specialized courts, which are more therapeutic in their approach. And the last report I saw on the Manitoba courts was that they are actually expanding. The demand is almost outstripping the initial expectation. And I think, it just feels that is a much more creative and compassionate way to deal with our many youngsters. Yeah,
thanks, Jeff.
Yeah,
I think you're absolutely right. Again, go back to New Zealand, because that's where I've got the most kind of connections. But Judge Fitzgerald, who's the kind of lead youth justice judge in Auckland at that time, created a specialist court there, a real kind of powerful opportunity to bring in various professionals and practitioners and have them in the room when cases are being discussed, and then almost kind of calling those professionals to account. And Judge Fitzgerald talks a lot about the professionals almost feeling like they're on trial rather than the young person, to be asked to come back routinely when the young person's back in court to answer what support they've given that young person and how they're reframing their lives and so on. And I think the journey for him then has been from, here's a specialist court that has in place all of these specialist interventions, but as you described, Jeff, when you realize that actually you start to get more and more young people with this, once you realize these diagnoses or these difficulties, you start to see them.
You see them a lot more, yeah.
Your specialist court practices need to move into your generic court practices.
That's right.
You can't wait for the assessment to tell you that there's a problem. You have to kind of recognize those problems and be able to deal with them in your day-to-day practice.
And I think this is where your mention of signs of needs, as opposed to having all these different diagnoses or labels or whatever, we need to look for signs of needs in any person in front of us. And whilst we still allow people to retain their dignity, and I think dignity is really a key thing here, isn't it? Because you start taking that away from children, it can damage them very long term. So it really, and also the whole generic reform. Universal tools is something that we're looking at a lot, because that's what we need. We don't want to be put into little segregated silos, right? We would like the world to be just broadening out, the line, the where we all can fit in.
Yeah.
And that's the same as you talked about, and I was very pleased to hear that. So
yeah, and it comes back to the first point I made, I think, and maybe I'll close on that one again. It's that I kind of feel a bit conflicted, because I use the language of disability because it opens those doors and raises those questions about disability rights and where we need to intervene, but recognizing that then demarcates within a group of, within a really kind of vulnerable population where we don't need to be demarcating. We need to be supporting everyone, and everyone that we're seeing in our courts is bringing some form of, it seems, health or trauma or adversity. So we fixating on a particular group and how we respond doesn't help us to respond to the population. And
I'm with you.
We can do that, the better, isn't it?
Yeah, I'm with you. It can be helpful sometimes with specific labels, but sort of our North Star is a world where, because it has widened the space that we can all function in, labels will become increasingly not needed, or maybe not needed at all. We're a bit away from that, but hopefully bringing us all together to talk about it will help.
Great.
That happen. So thank you so much for your time. I don't believe we have any more questions. Really, thank you so much for being here and for offering up your insights. Much appreciated.